This is Software Engineering Radio, the podcast for professional developers on the web at se-radio.net. SE Radio is brought to you by the IEEE Computer Society and by IEEE Software Magazine. Online at computer.org/software. DigitalOcean is the easiest cloud platform to deploy, manage, and scale applications of any size, removing infrastructure friction and providing predictability so developers and their teams can deploy faster and focus on building software that customers love. With thousands of in-depth tutorials and an active community, we provide the support you need. DigitalOcean stands out of the crowd due to its simplicity and high performance with no billing surprises. Try DigitalOcean for free by getting a $100 infrastructure credit at do.co/SERadio.
Welcome everyone to Software Engineering Radio today. I'll be your host. My name's Kim Carter, and today we've got István Lam. István Lam is a cryptographer, computer scientist, and entrepreneur. He's the co-founder and CEO of Tresorit, the end-to-end encrypted file sync and sharing tool. In 2016, István was featured on Forbes Europe's 30 Under 30 in Technology list as an inspiring young leader in technology. In 2017, he received the Digital Solutions Special Prize at the EY Entrepreneur of the Year Awards. Welcome to the show, István.
Welcome, everybody. Thanks for inviting me.
We've had shows on attack surface reduction with Natalie Silvanovic. That was show number 330. And we've had another related show, End-to-End Encryption, with Peter Budai, show number 321, also from Tresorit. And also a disclaimer, I use Tresorit myself and have found it to be excellent.
Thanks for the nice words.
There's a relevant article from the IEEE Computer Society on today's topic, the impact of the new European General Data Protection Regulation, that's GDPR, on the Information Government's Toolkit in health and social care with special reference to primary care in England. Now today we're going to be discussing how to build software with privacy by design in mind. That's a GDPR requirement. So I'm just going to start off with some basic questions. Can you explain, István, what GDPR stands for, what it is and why it came about?
Sure. So GDPR has been introduced in the EU in 25th of May this year. So it is in effect right now, and it regulates how European data subjects, how to handle the data of European data subjects. And it does not stop at the border of EU. It actually, software engineers and everybody or providers need to take care of this regulation even outside of the EU. So whenever you are handling the data of an EU citizen, EU resident, you need to comply with this regulation. And it is actually, I think, a quite good standard, and it might be a potential standard, a global standard for handling private data. Because if you look at, for instance, Brazil, they just followed this regulation. They implemented something quite similar to GDPR. And Mark Zuckerberg himself told the congressional hearing that US should introduce something similar to GDPR. I don't know how serious he was, but GDPR itself sets a new way of looking at private information and private data. And I think this regulation can take back the trust in the industry. Because if private individuals, lose trust in our industry, in a software industry, and the cloud and everything else, then no data will be transmitted to these systems. That means big harm for the industry. It's something like people are losing trust in banks and not taking their money to the banks. So if this regulation, I think, is important, not just because for private individuals, but it's also from our industry players' perspective, because that can reinitiate trust with private individuals.
Who does GDPR affect, and who's responsible for creating and enforcing it?
So enforcement is done by the local or national authorities, data protection authorities of the member states, meaning 28 different authorities. So even it's an EU level regulation, it's an umbrella regulation. They are still a little bit fragmented by how is it interpreted by different authorities inside EU. But at least the language is the same in every country.
So who actually has to abide by the GDPR? Is it basically anyone that's responsible for EU citizens' data?
Actually, anyone who is handling private data. That can be a dentist, that can be a lawyer, that can be a simple web shop where people are providing their name, their shipping address. So anyone who is storing, handling private data need to follow the regulation. And I think that pretty much every businesses, it's quite rare you don't store any private data. If nothing else, your employees' private data. So if you have employees, if you have customers, you most probably need to follow the GDPR.
So as people creating and maintaining software systems, how does GDPR affect us, like as software engineers, and why should we care?
I think there are different levels of software engineering or different type of companies who should follow. One is the first level is perpetual license software producers. The old way, that when you create something, you burn it on CD and you sell it. But when you do that, you are actually not handling private information with the software. You are not the one who are providing the service. You're running the system. Someone is buying that software and installing and then running that. In that case, you are not touching any private information. So directly, you don't need to follow GDPR.
Right.
However, your customers will need to follow GDPR. And if your system is not designed in a way that they can effectively follow that, they will buy someone else software. And also, if you provide supports, on-site supports, you will touch private data, and then you need to follow this regulation. So that at the second level is when you are providing some sort of high-level engineering support, or you are actually selling on project basis hours, development hours, and in an environment where your employees are actually handling or can touch private data. This means that you are not every day exposed to private data, but you need to think through internally and you need to implement internal policies that how that personal data should enter to your company. For instance, if your software engineer is doing a debugging for a customer and you get a database dump or memory dump and for that debugging, and that might contain private data. It is okay to have that. It is nothing you should avoid if you cannot provide a support. You can make so that you can regulate and you can implement policies which you can underpin why you need to have access to the private data. But once you finished with, for instance, debugging, then you need to, for instance, delete the data, or you need to find reasons to keep that data. So that I think is the second level. And the third level where you expose every day for handling private data, that's software as a service and e-commerce. When software engineers forms an integral part of the data processing, you are not just developing, but you are maintaining the live system, and that makes basically an integral part of the data management. But all this from the level one is an importance. It is important to keep in mind that someone in the process will need to touch private data.
Yeah, so usually you'd just anonymize any data provided to you for debugging anyway, wouldn't you? I mean, that'd be the best approach.
Anonymization is, yes, it is. It can be an approach, but just imagine the use case what I just provided when you get a database dump, and the customer says, "Please find a bug."
Most businesses that I've worked in, we won't accept a database from a client unless it's been anonymised first. What are the potential fines if you violate the GDPR? Is there any kind of strike or warning system, or will your business be penalised immediately?
There is a warning, and there are actually quite a few countries where, for instance, in Austria, where they had implemented a law which says that the first time you get a warning first from the authorities and not a fine. But if you have negligence and gross negligence, or you are doing really bad things with the data and willfulness can be proven, then you may get the fine right away.
Okay.
But if you make a mistake, an honest mistake, then yes, there is a warning. And the warning might be also they can and force you to stop doing something or change the way how you manage it. That's also a sanction that, for instance, you are collecting the names through when someone is downloading an ebook. And the authority can say that, oh no, you should not collect the names or the email addresses for whatever, so that you should not have the newsletter implemented on your website, just provide a newsletter or the content of the newsletter on your website. That is a sanction in a way, because for multiple reasons, companies may need to collect, want to collect that data. And if you don't follow that advice or that requirement, then you may face with a big fine. And the fine can be quite high. So it can be up to 20 million or 4% of your global revenue, meaning that the group level revenue. So that I spoke with a subsidiary of a huge global company, a CEO of that subsidiary, and he told me, I mean, he has a couple of thousand employees, so that it's not a small entity itself, but the company, the global company, is a multi-billion-dollar business, and 4% can be more than the entire revenue of that subsidiary. So that just think about it, especially if you are working for a larger entity, larger enterprise, how big the fine can be. And that's why you need to look at how to implement GDPR. And that's why, as a software engineer, you need to design a system which can be compliant with GDPR, because customers will pay an extra for that, for sure.
The US government often present that there is a security privacy trade-off with the Patriot Act, for example. The government, for example, demand access to all data in USA to supposedly keep us safe. Trading privacy for security. What are your thoughts around the so-called trade-off and how it relates to GDPR?
Well, in a broader sense, we are a social entities as human beings. So when we are interacting with each other, we are exposing or giving up on our privacy, for sure. So there is always a trade-off. We don't want to limit ourselves to a room and not providing any information about us. Privacy and the GDPR itself is not about limiting everything. It is about letting the people know and letting the people control how their private data is used. There is a metaphor I read on the other day that basically big US companies could, and global companies, could go into your apartment, having a key to your apartment, and look around and do whatever they want. GDPR is just a requirement that they need to knock before they are doing so.
Right.
So it's yes, there is a trade-off, and GDPR is not limiting that trade-off. You can sell the data to a third party under GDPR, but you need to let people know that you are doing and what you are doing with their private data.
So there's 99 articles of compliance for the GDPR. Which points do we need to focus on? What is the bare minimum we need to understand and do in order to be compliant?
I think one of the most important parts, but actually, if you read the other parts, you will conclude that's not a requirement that's in your best interest to follow. Article 25, data protection by design and by default. This is the privacy by design, but that is privacy as a concept that when you design a system, you from day one, you need to follow the principles how you will manage the private data in that system. But if you are actually read through the other articles of GDPR, you will realize that it's not a requirement. This is in your best interest to follow. It is something like as an engineering guideline that when you are designing a big building with apartments in it, and a guideline that you need to design a bathroom and heating inside. Because if you don't design from the day one And if you're not thinking about bathrooms, just imagine you build up the building, and then later on you need to modify that building to have bathrooms. That is, that's a lot more work. So it is much easier to have it in mind that you will need to have bathrooms in that building, in those apartments, and that should be something obvious. Actually, in the 19th century, it was not obvious, and there are many buildings built without bathrooms and apartments without bathrooms. And later, when it became a requirement, they needed to modify the entire building. So it's not a metaphor which is silly, but actually things changed, regulation and requirements of the people changed, and then the existing systems need to be changed, and that was actually quite expensive thing to do. It's much easier to start from day one, having it in mind that you need to have it at the end. So getting back to data protection by design, or the privacy by design, there are several fundamental principles of this. The first is being proactive, not reactive, and preventive, not remedial. So that when you are designing your system, you try to design in a way to prevent things rather than on a lean way of manage the issues later on.
Yeah, sure.
The second is privacy as the default setting. So that when you are managing private data, then you need to do it in a way that's the default, and because default rules. If you are having something else, for instance, if you have a data collection and you're exposing someone to a more extensive data collection, you need to set it up in a way that's the less of that. But there are ways when you cannot do on the complete privacy. Just think about being a headhunter. And then when someone is applying a CV to your system, you cannot say that I will not sell that data to the companies, because that's the basic nature of your business. You are going to companies as a headhunter, and you are selling private data, the CVs, to companies. But that's the nature of the business, and that's the way how you do, and that's the expectation of the customer.
Oh, right. Okay.
So that the default setting as a privacy should reflect your business and your way of protecting data for individuals. For instance, as a headhunter or a headhunter website, that data should be protected from anyone else than the companies you are connecting with. So that just limiting to the basic one.
So we're going to move into a section on terminology now. What are the specific roles involved in GDPR compliance, and what are their responsibilities? I noticed that there is like a controller, a processor, a data protection officer, DPO, and subjects. Do you just want to define what they are?
Sure. So the data subject is a natural person, and its importance when we're talking about private data, it is always connected to a natural person. If it is not, then it's not a private data. That's simple. It will be extended by a privacy regulation to the metadata, and even for metadata, not about just private individuals, but just staying at GDPR, the data subject is the person who can be identified with that data in a way, in a direct or indirect way. And it is important that identification part, how you can do that. But let's jump. So the second rule is the controller. The controller is the first entity, it's usually a company, who's entering into a relationship with the private individual. For instance, the website, provider, whatsoever. And there are processors and the sub-processors of the data. So that, for instance, if you are running a website and you are running a web shop under that website, and people are submitting their private information through that, and you are running it in Amazon. Amazon is a processor. You are, as a controller, having liability to your processor, so that if they are doing something wrong or if they are not following the rules, then you are liable for that. This is a little bit more complex because the processor has his own liability as well, but your relationship is regulated through the DPA, Data Processing Amendment or Agreement. So the controller and the processor need to sign that, and the processor needs to follow what is set in that. If the processor tells that I will resell that data and you sign it, then the processor cannot be held liable.
So what's the data protection officer?
A data protection officer is actually one person, or it can be a group, so that one person and a group under reporting to that person. It's a role who's having certain liabilities and certain responsibilities to inform the management about risks and keep the data in-house. It's something like an accountant of data, basically, inside the organization. The European regulation try to implement that it's, data management is as basic thing as having an accountant. So the role is basically is like close to the CISO role. It is a something like compliance officer. So that those are, I think, the closest roles under other jurisdictions.
So as a software engineer, could I have multiple roles? And if so, which would they be?
The software engineer, as I mentioned, software engineer can be a DPO, first of all, so that can be in a situation, because the DPO, the most important thing, requirements need to understand how the data is processed in that company. And if the software engineer is the right person to manage that, then let's be it. But that DPO needs to also follow regulations, so it is good to know the regulations and combining that knowledge with that. But besides that, a software engineer, as I mentioned earlier, there are, I think, the three levels I mentioned, how they touch the personal data. One is a software engineer as a development of perpetual license software. The second is a software engineer as a provider of high-level supports, or working on a project for a customer. So you are touching someone else's data. And the third, when you are a software as a service provider or e-commerce. And I think those levels, when you are working as a software engineer for companies, those are the levels when you need to think what is the risk and what's the exposure for private data. Because the more you are exposed, the more you need to worry about that, and then the more you need to know about it.
Yeah, so what's the easiest way for software engineers to actually know what they need to be considering rather than reading the 99 articles?
I think, circling back to the privacy by design, I think there should be, when you are architecting the system, you need to think about the privacy of the individuals. When you are, for instance, having an entity relation diagram, you need to ask yourself, okay, what is the risk? Is it a private data? And if it's a private data, then you need to set a level of the risk for that private data. What I would suggest, and there are multiple ways to look at that, but what I would suggest is having a 4-level risk level, implementing a risk level for private data. So not every private data born to be the same risk if it's exposed or go to the public. For instance, sexual orientation is not the same risk as, for instance, IP address or a cookie on your website. If you lose that data, if there is a breach and that goes out to the public, you may face higher fines if you're publishing the sexual orientation of someone, for instance. So what I would suggest is categorize, and the categorization is the following. And the number one is sensitive private data. And sensitive private data is actually defined in GDPR. There are racial or ethnic origin, political opinions, religious or philosophical beliefs, trade union membership and processing of genetic data, biometric data, data concerning health, data concerning a natural person's sex life or sexual orientation. That is the sensitive, that's the category of the sensitive data. And if you manage that, you need to take a deep breath and later on take it quite seriously, because if you don't have a good reason to handle that information, you better not to manage that data.
Yep.
Then the second level, I would say, is the data where individuals can be identified with just that information. For instance, first name, last name, birth date. That tuple is something you can use to identify someone without any other system. So just looking at this information identifies the person. The third level would be, for instance, something that it doesn't identify right away, But with looking at the system, that tuple, and it's not a record, that tuple doesn't identify you right away, but it takes for someone or another software engineer or well-educated professional to identify it with just a little work. And for instance, phone number. If you are not a telco provider, phone number can be something like that in multiple systems. So for instance, if you are not having phone numbers or connecting phone numbers to names, just having phone numbers naked, that itself doesn't identify in your system a private individual, but you could look it up in a lot of databases. It can take just a few Google search to find the person.
Yeah.
And the fourth level is something which requires more work and connecting databases which may not be public, but that can be used with a little bit more work. Someone can identify you. I would, for instance, most of the cases, I would put IP address in that category. But again, it really depends on how you are running your system, what you are doing. But IP address, if you are just logging IP address of website visitor and you're never connecting it to a private individual's name, it would take a lot of work for you to connect it to someone else. But it's possible.
Yeah. Yeah.
So once you have that categorization, and there is the fifth category, it's not private data. So for instance, a log of a system, or if you're working for manufacturing, the difference log in that system is not considered private data at all. So when you looking at the entity relation diagram, you just mark these which data considered to be private and what is the level of the risk. And once you have that, then you start thinking of I would suggest the following framework. That first, thinking why you are collecting that data. What is the reason? It is important from GDPR perspective because once you document that reason, you can go to an attorney and consult with that. Just write it down as a professional, but you don't need to overthink. You don't need to use the legal language. It is simple documentation. What is the reason you are collecting that data? For instance, in a CRM system, storing information can be for legal purposes as well. That I received an order, send me this package and so on. And the reason why you're storing, because if there is a dispute, you need to prove that an employee of your customer has ordered something. Or it can be, for instance, if for invoices. Invoices have private data as itself, but the authorities require you to store that. So what is the reason why you are doing that, and document that?
Yeah. Okay.
And it can be a business reason as well. And now we are not talking about documentation which might be GDPR compliant, but the work you need to do before you go to an attorney.
Cool.
Then the second, think about how that data will be deleted. Can you delete that data? And if you don't know when that data will be deleted, better not to collect it.
Mm.
And better cut it out, because if the data after, for instance, termination of relationship with the customer needs to be deleted, unless you have a reason to keep that, but you still need to have a deadline for deleting that. Again, the invoice is a perfect example. Even if the customer tells you delete everything, and GDPR tells you in that case you need to delete everything except you have the right and you have the reason to keep that, so that you need to document why you are keeping it. Invoices because of tax authorities. I mean, it's that simple. So if you have documented, then it's also how that data will be used later on and so on. But if you have that in your hand, at least documented the reasons when you will the life cycle as well, then you can go to an attorney, and then the attorney will able to provide you advice based on that situation, what to do and how to write a privacy policy, for instance, which covers your way of managing data. Because in a lot of cases, as I mentioned, GDPR is just about letting the people know what you are doing. And if you are doing something which is undocumented, it is not included in your privacy policy, then it's illegal. But maybe if you just include it in your privacy policy, then it can be good. Sometimes it is not that easy. Sometimes you cannot collect data by just including information, because if you, for instance, you don't have the reason, you cannot underpin what is the reasons to collect that information, then GDPR tells that actually data stacking or collecting data because we don't know what we will do in the future, that is something you cannot do, even though that you write it down in your privacy policy.
Ever thought about a master's degree to advance your career as a software developer? The UC Irvine 16-month professionally oriented Master of Software Engineering program is made for you. Taught by experts in the field, the program combines hands-on experiences in fundamentals and latest trends with professional development for successful careers after graduation. Hurry, applications for fall 2019 are due December 15th. Visit mse.ics.uci.edu to learn more and start your application today.
So just on the backups, so what if a user wants their data purged or modified? Does the business have to purge or modify all copies and backups, including offsite?
The basic or the simple answer, yes. The more complex answer is it depends. It depends because just think about it. What is the reason of the backup? The reason of the backup is if something goes wrong, it's not the redundancy. It is you have most probably you implement redundancy in your live system, RAID, HDDs, multiple servers, copying and shadow copies of your online system. That's not for faults in your system. It is more like someone hits delete accidentally and delete everything in your live system. Then it's better to have a backup. And if you are, for instance, managing the data, for instance, medical data for a hospital, or you are a bank and you're managing the people's money, if the data is deleted, that will have a serious consequences for the business and for your customers as well. So the backup is a way multiple ways to protect the private individuals as well, and their interest as well you have to have a backup.
Sounds like the requirements are not that prescriptive, what we're supposed to be doing with our backups.
Yes, because we were thinking with our GDPR lawyer that, for instance, if you take back the tape drive, the only tape drive for, purging private data, that simple records, that might damage the backup itself. So what you are doing is actually risking, in case of an emergency, to get back to the normal level.
Yeah.
But the simple rule is you need to purge the records from your backups as well. The more complex is, think it through.
Yeah.
If you think that there is a good reason, and you can, by consulting with your attorney, there is a good reason and you can find a legal base storing a backup and not deleting from the backup, then there might be a way not to do that. And you say that, okay, I'm just keeping it in a bunker, close down, and there is a process that I implement a Chinese wall that my online system cannot get to the backup because it is stored so far by another company, and when we are restoring, there needs to be two people who's who's recovering the encryption key of the backup, and so on and so on. So you implement in a way that the data cannot be used for anything else than just for the backup, and you set the right dates that, okay, I'm keeping the backup for 1 year, whatever.
Yep.
Then you can say that, okay, I don't delete because the risk of, for instance, destroying the backup or damaging the backup is higher than the risk of someone's data is in the backup.
So the entity holding the subject's data must be able to erase all the data of the subject, so at the subject's request, right?
Yeah.
So that's like the subject has the right to be forgotten. But what sort of things do we need to do to make this possible?
Again, it starts from the design or how you architect the system. And that's why when you are a software developer who's not running a system, but you're developing a software which is used by people who are managing private data, it's better to keep it in mind because your customers will demand a way of deleting private data. They will have a headache And if you can provide a cure for that headache, that's good business. So if you cannot architect, because it's a legacy system, and most of the systems right now is legacy system, we will not throw them away and we will not start scratching. So if you need to design bathrooms in a building where it was not prepared for, in that case, what I would do is start with a whiteboard and drawing with a green and a red pencil or marker on that and draw a big rectangle saying we delete everything. That's with red. And then starts drawing things you need to keep. That what is the part of the system you need to keep, for instance, invoices. Invoices need to be kept for 5-7 years, depending on the jurisdiction you are in, after determination of the relationship with your customer. Then it is something you need to delete in a different way. And then you ask, okay, you need to keep logs because of fraud prevention. Okay, there is a reason why you can keep that logs for a longer period. Then you draw a little rectangle saying that, okay, logs can be kept for another year, and so on and so on. And then you start, when you have these green rectangles on the charts, you have a large set of data you want to keep or you should keep as an obligation, but then you continue with the red and saying that, okay, now what can I delete from the green ones in order to minimize the impacts? For instance, in the logs, you can delete the IP address or just the last octet of the IP addresses and saying that, okay, that's something cannot be used for identifying a person, but at least I know where that was coming from.
So the subject has the right to access and extract and modify their own personal data with GDPR, right? So what do we need to do in order to make this possible?
First, I think when you design a delete system or how you delete the private data, that system also needs to be able to list the data. So it create a dump about the user. And once you have the dump, you need to be able to present that information to your customer by individual. So that in Facebook, for instance, if you go to your account, you can export every data Facebook stores about you. I mean, they say it contains every data, but it's a hell lot of data and a lot of details what you can do. And you need to be able to do the same. The other changing and right to, if something, for instance, that your name has been recorded with a typo or something else is stored about you in the wrong way, the person needs to be able to ask for change and you need to have the process to do so. It doesn't mean you need to have, an online system on a website where customers can change every data, but you're, for instance, a support personnel or someone needs to be able to change that data later on. So that there needs to be implemented a way to do that.
Moving into a planning and implementation section. When GDPR was brought into law, we saw a number of our websites like the Los Angeles Times do things like ban EU from viewing their website while they figured out what to do. How does this sort of strategy work? Many EU citizens live in non-EU countries. Does this really mean...
I don't know. I mean, I don't think it's the right way. There are many other companies, for instance, Twilio, they implemented GDPR in a way that everyone got the GDPR compliance service. So that globally, because they said it's easier to implement as a global company GDPR in their entire company than, just separates for EU and non-EU citizens. And Twilio is usually not a direct relationship with the private individuals. They are a processor most of the cases, but they designed a system for everyone to comply with GDPR, and that is something which points out that GDPR can be a global standard. And yes, Los Angeles Times maybe have the ability to ban, but it's also a bad message to the people living in the US or living somewhere else that they cannot follow a simple regulation to disclose how the private data is managed on the website. I think that as we go on, that will be a stigma. And stigmatizing that you are not respecting people's privacy, it's not a good message.
Do you know of any specific frameworks or tools that make it easier to meet GDPR requirements for software engineers?
Unfortunately, I don't have something which could be considered as a silver bullet, especially that the many ways of managing data. What I would, for instance, as a tool, a usual tool is a data catalog. There are multiple data catalogs where you can document. It's more like an entity diagram or meta entity diagram. So it's a meta database containing the private data, what you are having, where you are storing that. And you can document where you are storing. So what I mentioned, the documentation inside your system, that can make your life easier. But that filling in that database or that data catalog, you can have scripts, you can have a lot of things to ease that process, but at the end, you are the one as a software engineer who will design the system, and you will be the one who knows how data is handled in that. It's something like, is there a tool for writing a software from the customer's requirement? Yes, there are some, automatize software development, but most of the cases it's better to do it in the old way and go through the development process. So there are other tools like AI tools which can help you identifying personal data inside your database, giving you a holistic view, especially for legacy systems. You need to think through how that private data, and you need to sit down to document how the private data flows into that system, so that AI tools can scan to point out the risk that, okay, these records have, or these tuples might be viewed as a personal data.
So what are some of these tools?
For instance, Azure has a data catalog, Microsoft Azure, and there is a way to have that documentation in place and importing. But it's not again, silver bullets. Slightly more sophisticated way of documentation than having a spreadsheet. But
So we've talked about architectural decisions. What about coding, testing, logging, monitoring? What parts of these activities do we need to modify, and how do we need to modify them to satisfy GDPR compliance?
I think one principle, I would say that centralize your data, centralize the private data in one database, or as few databases as possible. I mean, when you design a database on relational database, it's a usual way of thinking that, okay, you minimize and you only have one place where the data is stored. But for performance or other reasons, you may have copies of personal data in multiple other systems. So what I would suggest that, for instance, you have the private name, first name, last name, address, even the IP address, if you are connecting that, credit card, whatsoever, in one central place, and you only use foreign keys in the other systems. So in a way that you are anonymizing in other parts of the system, the private data, you are using random tokens instead of the private data, which will slow down the system in fact, because a join is something which takes time in a system, but that at the end, when it comes to deleting the data, you need to delete it from that central database, and then that foreign key can be in your system forever.
Yes, I mean, like often you'll have quite a few different parts of an organisation, like you'll have marketing, research, customer relations, support. How do we design for tracking all the data stores of the organisation across all of those areas? Like, say, for an example, you may have a user that's got parts of their identity in each one of those areas of your organisation, and they're all in different data stores, and there's really no easy way that you can pull them all together and centralise them. So how do you actually track them across all of those areas?
It is very complex. What I would suggest is the first step. I mean, first step is just think through how the data flows before you do anything. So that just have a data map where the data flows. And that data map is basically when you sit down with different heads of the areas and you document where the data should go and accidentally can come up. So that is more of documentation, talking, meetings, so on. But then, obviously, you will make mistakes. People will forget about, oh yeah, we are using that reports from time to time. We are exporting to CSV and then doing marketing, doing a little bit transformation here and there, and then I forget to delete that CSV on my laptop and blah blah blah. So what I recommend, so after you have this data flow, you document how the data goes inside your organization and what are the reasons. It's still not the compliancy, so you haven't checked with attorney whether it's good or not, but at least you know you are in control. Then the second, you audit that documentation. The auditing can be multiple ways. One way, which is quite effective way, is it's a metaphor for angiography. So angiography is used in medical imaging when you are putting some special liquid into veins and then you see how that special liquid goes through your body when you are in an MRI.
Okay.
You need to do something similar. For instance, you drop fake information into the website signups and then scan all your laptops, your employees' laptops for that private information. And then you will find out that, oh, that information is, that marketing is exporting a CSV from time to time from this system and they forget to delete. Or we forget that we have another software as a service system for customer support because customer support may have multiple systems they are using. And so on and so on. So, but if you cannot inject, for instance, fake information into your system, you can just select random ones and search in your system for that and search the databases for that information just through the dumps. You dump the entire information and then you can see that, okay, is that record documented? Is it something we are knowing about? So that the first step is really identifying the way how information spread across your organization. That is the single most important part of that. And I can tell something, it won't be holistic or you will not cover 100% ever for sure. So you need to stop at one point and say, okay, this is what I think covers the most of the ways how we are managing private information. This is where it spreads. I know there are ways, but let's start doing risk analysis based on that because you can do this forever. And then you look at, what are the risks? What happens with that CSVs on your system? And when you do this risk analysis, you are actually doing something which is required by GDPR, basically, so that this process needs to be documented as well. So when you are doing that, okay, laptops are having encryption and login and screen lock and so on and so on and so on. So I consider this a medium risk for that or low risk or whatsoever. So you document that thing and then you are doing a risk mitigation. So if you find that, okay, maybe we should turn on, for instance, encryption on the laptops where private information is stored, disk encryption. Or maybe we should rather not have, exporting CSVs or Excels. We should rather have an online interface for the marketing where they don't export, but they can use from the browser and manage the data from the browser so the data is not exported. And so on and so on. So you do some risk mitigation, use some steps. Obviously, you will not able to mitigate all the risks, but you need to start from the top. What are the top risks you identified? And you document the reason, okay, this is what I have time for doing, this is what I will do. And this is the old way. I mean, if you have implemented ISO 27001, this is quite similar. If you have done HIPAA or something else, it's quite similar. But this is called privacy impact assessment. And if you are managing a lot of private data, you need to do. So you're obliged to do that privacy impact assessment. But if you're not obliged because of your size, of your nature, I would still recommend doing it because this is quite a good way of looking at your system, your organization, how they are managing data.
What happens when an employee decides to deploy a rogue trial or test system using personal identifiable information, whether accessible externally or just internally? Does this create millions of dollars of liability for the organization?
Well, if it's an accidental thing, you may face liability, especially if you didn't do privacy impact assessment and you haven't identified risks and you didn't do anything to mitigate the risks. So there were obvious low-hanging fruits how you could prevent that accidental leakage. Then for sure you are liable.
So how do you stop your employees doing things that you don't know about or that are going to expose you like that?
There is, I think, the two things. One, your system needs to be able to manage people and accidents. The second is awareness and awareness training. So you need to educate your employees about the way how they need to manage the private data. And if you didn't do anything about it, then you may face with serious consequences. But if you did and it still happened, you may that can be this is hard to judge, and it is something you need to consult with an attorney case by case. But if you did the privacy impact assessment, you are seriously doing improvements on, and you are doing awareness trainings, and still happens a data breach by your employee, then the third thing, if that happens, you need to act professionally. And there are certain requirements how you need to manage a data breach. You need to, for instance, let the authorities know in 72 hours. So that there are requirements in GDPR that the process how you manage a data breach. And if you manage the data breach in a professional way, that can seriously lower the consequences. It can be just a warning at the end, not a fine. You get a warning, okay, you need to implement, and you already know that we need to do something about it. You need to improve your processes, but there are things, and the GDPR is not something that tells that okay, you cannot make mistakes at all. You need to make steps in order to minimize those risks.
So how does defending against the employee doing this differ from an outsider doing something similar?
So first, privacy impact assessment, and look at it. Is it really necessary, for instance, that employee having access to that data? Or is it the way how that the employee should have access to the data? For instance, support. Should support able to get access by typing in anyone's email address, get access to the data to that person? I mean, most of the people would say, yeah, but what if you implement at support simple questions that please tell the last four digit of a credit card, or please tell your name and birth date or whatsoever. So some identification process for the customer which works through the phone, through the email or whatsoever, and your system does not allow the personnel to get access to that information unless that authentication is done. So that, for instance, support agent need to type in the last four digits of the credit card number, and then the system allows you to enter. So you need to design in a way that people cannot make mistakes and the risks are minimized by the system. And also the people need to be trained and tell them the stories what happened and learn from if something a breach happens or close to something a breach, then it needs to be communicated how that should have been handled. There was a customer who came to us and asked about canceling someone's account, claiming that was his account and deleting all the data. And it came to actually to the data privacy officer, the DPO, and or privacy attorney, that they came to ask how could they hand over the data and how could they manage it, because the system stopped them to do that. But the customer was saying that they will sue us if we don't do this and that. And it turned out that the customer was not identified in the right way. It was an unauthorized or unauthenticated channel when how they communicated, so that they couldn't make sure that the customer was the one they're talking to. Luckily, they didn't hand over any information because they were trained, but they were thinking and have started doing it, but the system stopped them. So that sort of social engineering could have worked on them if the system doesn't stop them, even though that the training and even though the awareness what we try to raise in our support personnel, later on it turned out that wasn't the social engineering at all. Just simply that was the customer, and that was the customer claim, just didn't have the way to authenticate himself. So it turned out good, but still we noted as a breach or close to a breach because the support people wanted to override the system. And then we use as an example to tell that what could have go wrong. in that one case.
Yeah, so we're going to have to start wrapping up, István. Just in conclusion, do you know of any good privacy awareness and training resources?
What I would suggest is read through the GDPR summaries. There are many, many summaries of the articles, but at least read through the 99 article titles, at least.
Yeah.
So that start with the source. I think it is important to understand the principles in the GDPR. It is important to understand what are the topics you need to think about first. And the awareness is a tricky thing. Sometimes you need to go quite deep in that territory. If you're working with, for instance, healthcare data, that's a quite special territory. As I mentioned, that's a sensitive private information. That is a completely different way than, for instance, managing e-commerce private data. So I think there are many good channels at tresorit.com. We also publish some materials and videos about that, what we recorded on previous shows.
I've got a bunch of those in the show notes. So thanks for joining us today, István.
Thank you for having me.
For Software Engineering Radio, this was Kim Carter.
DigitalOcean is the easiest cloud platform to deploy, manage, and scale applications of any size, removing infrastructure friction and providing predictability so developers and their teams can deploy faster and focus on building software that customers love. With thousands of in-depth tutorials and an active community, we provide the support you need. DigitalOcean stands out of the crowd due to its simplicity and high performance with no billing surprises. Try DigitalOcean for free by getting a $100 infrastructure credit at do.co/SERadio. Thanks for listening to SE Radio, an educational program brought to you by IEEE Software Magazine. For more about the podcast, including other episodes, visit our website at se-radio.net. To provide feedback, you can comment on each episode on the website or reach us on LinkedIn, Facebook, Twitter, or through our Slack channel at seradio.slack.com. You can also email us at team@se-radio.net. This and all other episodes of SE Radio is licensed under Creative Commons License 2.5. Thanks for listening.